please the court, Sarah Richter-Perkey for the appellant Jennifer Erdman. I'd like to reserve 5 minutes for rebuttal, please.
Very good.
Your Honors, this case comes before the court after a remand to the trial court for a number of errors relating to the division of the estate and the award of alimony. The only remaining issues before the court today are first, whether the trial court erred in failing to again award Mrs. Erdman any alimony whatsoever of any amount, duration, or type. Secondly, whether the trial court erred in failing to again award Mrs. Erdman any attorney fees. And finally, Mrs. Erdman's request on appeal for an attorney fee award. First, addressing the issue of alimony. Every factor, Your Honors, in the statutory analysis of alimony mitigated in favor of Mrs. Erdman except fault for the demise of the marriage. In this case, Mrs. Erdman gave up her career in order to stay at home and be the primary caregiver to the party's children and to be a homemaker. The parties were married 17 years, during which time Mrs. Erdman had 6 children at the behest of her husband, who was Catholic and refused to allow Ms. Erdman to use contraceptives because he said it was against his religion. Mrs. Erdman more than fulfilled her role as a homemaker and a mother. She took the children to medical appointments. She performed all the grocery shopping and the cooking. She cleaned the home. She bathed the children. She breastfed her children. She comforted the children when they woke up in the middle of the night. She made lunches for the children. She washed the laundry. She picked the children up from school every day. She changed the children's diapers. She got the kids ready for school.
Perkey,
Yes.
Sorry to interrupt, but I wanted to ask you, in the brief, you sort of sum up the end with the statement that it appears that the court was, again, unable to properly consider the parties' respective need and ability to pay.
Yes.
And I'd like, before your time goes, you
Yep.
focus in on what those two elements show here. I mean, I know that you pointed out, it seems like the court found a $4,000 deficit in Mr. Erdman's income, and you point out several items of expenses that you felt were properly or not properly a part of his expense statement. So where does that leave us in the final analysis? I'm not sure.
Well, first, Your Honor, I would say looking at Mrs. Erdman's need, it was largely unrefuted. She has submitted an income and expense statement which showed a need of $6,000 per month. The court made an unsubstantiated finding that she had no need for alimony, and so I think that that's completely unsupported by the record. With respect to Mr. Erdman's ability to pay, he also submitted an income and expense statement that showed a deficit of $1,900.
$1,900, okay.
Yes, Your Honor. However, there were a number of inconsistencies in that income and expense statement. The first of which, he had voluntarily undertaken the payment of private school for the party's 6 children. This was a cost of $42,000 a year or $3,500 per month. Mr. Erdman said multiple times during the trial under oath that he did not want his desire to pay for private school for his children to undermine his payment of alimony to his wife. Also, the proof showed that historically, Mr. Erdman didn't even pay that cost. His brother actually paid that cost on the party's behalf. So I think that we've got $3,500 right there. In addition, Mr. Erdman's HOA cost was overstated, he admitted, by $440 per month. In addition, he included a loan against his 401k, which was $776 per month, which only had 9 payments left. Furthermore, he included expense for a company car that he leased through his brother, which he said he was going to buy from him, which would eradicate that payment. And also he had put down that he was paying car insurance, whereas the testimony later was corrected that his employer paid that cost. In addition, he testified that many of his expenses would be reduced post-divorce. First of all, he said he intended on refinancing his home in order to lower the monthly payment. 2, he said the parties had terminated their timeshare, and so that cost was eradicated as well. And 3, he said that he was intending to modify his medical insurance as well as his homeowner's insurance coverage, which would also reduce his overhead costs. But again, Your Honor, going back, the case law is very clear that in making an alimony award, you consider need, ability to pay, the most important factors, but the most important in a divorce is the need of the recipient spouse.
Let me ask you a question.
Yes, Your Honor.
You went over the Mr. Erdman's expenses. On Mrs. Erdman's expense sheet, she's showing that she has a need of $6,000.
Yes, Your Honor.
But weren't there some expenses that on that were actually lower that were determined on like $895 less than what she says on there? For rent, she was paying $1,800 instead of $2,500, but wasn't paying the garbage expense. A few other things like the insurance I think was being paid for by work. And I also wanted to ask you about, there was $1,000 being paid for tuition for her. Is it for her son?
It was for her, I think.
So is that, would that be included, should that be included?
I think that they should, Your Honor. Ms. Erdman testified that her income and expense statement, divorce attorneys a lot of times have trouble submitting these income and expense statements because do you submit it based on what your client is currently incurring, or do you submit it based on what their projected expenses will be? So during the divorce proceedings, Mrs. Erdman vacated the marital home and moved into a very small rental home. It was something that was supposed to be very short term for her with their 6 children, but to get the parties away from one another. And so that's that $1,700 cost that the court is that Your Honor is referring to. However, her income and expense statement reflected the anticipated cost of getting a very reasonably priced home for her and these 6 children to live in. So I don't think that it's overstated. I just think we're talking about a difference in what are you currently incurring during the divorce proceedings versus what will you be incurring after these divorce proceedings. And I think the latter is much more appropriate when we're talking about an alimony award.
And what about this tuition pay?
I looked back.
Was that Mr. Erdman's child?
The first child?
Yes.
Yes, the first child is not his biological child. When the parties married, this little girl was, I think, 2 or 3 years old, so she was basically raised as his child. But this was an expense that they had paid together throughout the marriage for the daughter. So, and it wasn't an expense that wasn't happening; it was legitimately happening. They were just like, well, should it be on her income and expense statement or not? But it was something that she was paying. So. Moving on to the award of attorney's fees, as the court is well aware, in a divorce case, the award of attorney's fees is in the nature of alimony and solido, and it's appropriate when the financially disadvantaged spouse would have to deplete his or her resources in order to pay their fees. In this case, Mrs. Erdman had to take loans from her family members in order to fund her divorce case. Conversely, Mr. Erdman used the marital income and assets to pay for his attorney's fees. So in denying Mrs. Erdman an award of attorney's fees at trial, effectively Mrs. Erdman paid 1/2 of Mr. Erdman's fees because it was paid from the marital estate, and she paid 100% of her own fees because she had to pay them with her post-divorce portion of the marital estate. Similar to the redetermination of alimony, Your Honors, the court engaged in no real new analysis. The court basically regurgitated exactly what it had said in the divorce memorandum and order and just deleted the provisions which the court found concerning with respect to Mrs. Erdman's family's business that she had no interest in.
What impact do you say that the court apparently in looking at the attorney's fees said that the court felt that the attorney's bill was excessively high due to her conduct and litigation tactics?
Right.
Respond to that.
Yeah, I think that there's 2 problems with that. The first is I think that the court engaged in what's called like a prevailing party analysis, looking at basically the court said that she had spent an inordinate amount of time and money on litigating the insubstantial determination of custody when the parties agreed to an equal parenting time schedule. The problem with that is twofold. First, prevailing party is not a consideration in award of an alimony award. And secondly, the parties didn't agree to this equal parenting time schedule until the close of Mrs. Erdman's case in chief. So for the first 6 days, the parties are arguing about custody. Mr. Erdman took the very unreasonable position at trial that Mrs. Erdman's parenting time with these 6 children should be limited to 130 days, Thursday to Monday every other week, although it was undisputed she had been the primary caregiver and a stay-at-home mom throughout the parties' marriage. So this wasn't something that she was needlessly litigating. This was something that Mr. Erdman put on the table saying, you're only going to see your kids Thursday to Monday every other week. And so that's the reason that there were these fees.
Well, what was the court actually talking about when it was talking about her conduct and litigation tactics?
Your Honor, I think that, frankly, I think that the court was offended that Mrs. Erdman had engaged in infidelity during the marriage and that she wasn't honest about it when she first was confronted with it. And I think that the court held on to that and wanted to punish her. That's frankly what I think happened in this case. I'd also just note, Your Honor, that we're talking about a difference of $15,000. So Mrs. Erdman's fees were only $15,000 higher than Mr. Erdman's fees. So I'm not sure how hers are so unreasonable and excessive.
All right, thank you, Ms. Perkins.
Thank you, Your Honor.
Good morning.
Good morning, judges. Elizabeth Russell of the Williamson County Bar for Mr. Erdman. First, I would like to say that it cannot be overstated that parenting children and maintaining a household is an invaluable contribution. And it's a contribution that one party must make or the parties must pay for someone else to make. And in this situation, the parties decided together that Mrs. Erdman was going to be the parent that stayed at home and undertook these obligations, taking the children to school, making their lunches, ensuring that they had clothing to wear to school and to their sporting events. Having said that, what we haven't gone through in detail are the things that Mr. Erdman undertook in his work each and every day. He also went to work. He earned an income for this family. He put food on the table. He ensured that the parties had the money to pay for the private school that they decided jointly together was important for them as a couple. So while Ms. Erdman undertook an incredible amount of obligation in caring for these 6 children, it can't be overstated that alimony isn't a reward for undertaking those obligations. Those are things that the parties together decided were important to them. And to now take the position that Ms. Erdman was placed into this household, forced to have these children, forced to raise these children, while Mr. Erdman, at the same time, is not only caretaking for the child that Ms. Erdman had when they first married, that was not his biological child, but is continuing to pay for that child's college expenses throughout the marriage and throughout the divorce proceedings.
The upshot of the appellant's argument here on the alimony component here is there was an abuse of discretion because the evidence preponderates against some of the factual findings about need and ability to pay here, is what I gather. So,
Yes, Your Honor.
does the evidence preponderate against those factual findings?
No, Your Honor. Our opinion is that it does not preponderate against those findings.
So your client's income and expense statement during during the trial, what did it show his actual ability to pay? The position is still it was zero.
Yes, it did show that his ability to pay was low, and I think that some of the discrepancies...
Low, but not zero.
It was not zero.
Okay.
Some of the discrepancies that were mentioned earlier were actually discrepancies with Ms. Erdman's income and expense statement. For instance, the amount that was referenced earlier, she had listed $2,500 in rent versus the $1,795 that her rent actually cost. She also listed the garbage, $50 a month, which she didn't actually pay. Her car insurance was listed at $140 a month. That was paid by her employer, who was her father and her family business. The same went for the tuition to Western Kentucky for Ms. Erdman's child that she had prior to marrying Mr. Erdman. That was $1,000 a month and was coming out of a joint account. In fact, Ms. Erdman agreed and testified that her income and expense was merely a projection of what she estimated her costs would be. Importantly, she estimated those costs with all 6 children living with her. At the time, not only was one child on her way to college, but 2 others would there follow soon thereafter.
So is your argument here then the evidence does not, the evidence or record would support a finding that Ms. Erdman had no need?
I think what the proof at trial showed is that Ms. Erdman enjoyed a very unique career trajectory, despite the fact that she was not actively working outside of the home during the marriage. And that unique career trajectory was that her father anticipated naming her CFO of the family business and affording her the same salary that the other C-level executives were making.
So that sounds like something that would be considered later in an alimony modification situation, not when you're setting, I mean, that could or could not happen, right? I mean, why would you consider that now?
Ms. Erdman is already the CFO of the family business. He anticipated that she would be making the 6-figure salary within several years after the trial.
Within several years after the trial?
Yes, Your Honor.
So her income now was, what, $52,000 a year?
It was, her income at the time was $52,000 a year. She'd also received a substantial amount of marital assets. And she had also received throughout the proceedings, which were long and they were extended, she'd received $4,000 a month in family support, which was at the time considered by the trial court to be both child support and, in effect, transitional alimony of sorts.
When this case was remanded on the previous appeal, wasn't the court not supposed to take that into consideration?
Supposed to take, I'm sorry, which?
Not supposed to take into consideration what might happen, the speculative aspect of what might happen. That's why the remand occurred, as I recall.
Well, that was one of the reasons, and the court actually did not take that into consideration. There was a motion to alter or amend the judgment of the court based on, there were some post-trial facts that were discovered. And the trial court actually refused to consider those post-trial facts, and she denied the motion to alter or amend, which would have taken into account the fact that directly following the trial, Ms. Erdman had in fact been named CFO of her family's company. So the trial court rejected that argument and took the facts as they were at trial, rather than considering these post-judgment facts that we did in fact ask the court to consider on remand.
Well, if you took the facts at trial, as Judge McBrayer was alluding to, how could the court possibly find that there was no need?
Well, I believe the court found that there was no need because there was not an appropriate alimony that actually fit Ms. Erdman if she had some type of need. She did not need to be rehabilitated. She had not only the education, she had community involvement, she had participation with civic groups through the children's schools and in the community, and she also had the ability to rejoin the family business at the time. So there was any rehabilitation.
Excuse me.
I'm sorry.
Again, as Judge McBrayer alluded to, these are matters for modification that might occur in the future. I mean, the alimony in Futura would be modifiable. All of a sudden she gets $152,000 income, then your client can apply for a modification on the amount of the alimony. But to say there was no need based on essentially an uncontroverted monthly expense statement showing the need of $6,000, it's kind of hard for us to comprehend, I think.
I understand. The income and expense was controverted. So it was controverted by not only Mr. Erdman's testimony, but it was the trial court found that Ms. Erdman was not a credible witness. And that was also part of the analysis that can't be overlooked in this situation. Ms. Erdman was dishonest with the court time and time again about her extramarital affairs. In fact, during the trial of this matter, Ms. Erdman undertook, in a roundabout way, arguing with the court. Despite the fact that her marriage was not final, her divorce was not final, she took on with the court that it was not considered adultery or an extramarital affair, despite the fact that the divorce had not been finalized. So there were multiple instances where the trial court found Ms. Erdman to be not credible, where she was directly misleading the court and being directly dishonest with the court.
And so did that ever occur during her testimony about her expenses, though?
Yes.
And what specifically, or is that where you were talking about the tuition?
Yes, Your
Okay.
Honor. Yes, it was the tuition. She admitted that she had made projections based on if she were to buy a home. There were no evidence of her actual real expenses that were offered. And I share a different perspective than perhaps the appellant, in that what the trial court can analyze and what the parties can put together is a historical income and expense. And what they can look at are in the years going leading up to the divorce, what were the parties spending? And to me, I believe the trial court, they find that to be an appropriate, it's appropriate facts to bring before the court, so the court can properly determine, what were these parties spending before the divorce, before the hammer was dropped, before they didn't like each other and couldn't decide between the two of them who was going to take the children to school. That is an accurate means of assessing what the parties need based on what they've historically spent. Ms. Erdman did not undertake providing that factual information to the court. Rather than providing that 5-year look back, which is a very common thing to provide to the trial court when we're facing a divorce trial, rather she made projections on what her future need would be, and perhaps arguably what her need at that present time she believed to be, not historically what the parties had actually spent and what they would need moving forward.
Well, but how does that viewpoint work in reality when you have a circumstance where a couple's been sharing the same roof with 6 children and one of the spouses is going to be awarded or named the primary residential parent and has to provide space for 6 children? I mean, there's not a historical number that you can look at. And I can certainly see the argument that, yes, immediately after divorce, when you're trying to separate the parties, where there might be acrimony, that you're trying to get the first available place, and you're not necessarily going to be where you're always going to be in the very near future. How do you square that?
Well, the way that we squared that at trial was that Ms. Erdman had committed adultery during the course of the marriage. She was still actively involved in a relationship with one or more men at the time whom she had attempted to bring around her children. It was not appropriate for Ms. Erdman to remain in the house with Mr. Erdman, and the children were primarily living with Mr. Erdman. So for Ms. Erdman to engage in this extramarital affair and then choose to move out of the home so that she can continue to engage in this extramarital affair during the divorce proceedings was of her own choosing.
So would you say the trial court here gave preeminence to the fault in making the alimony assessment?
I don't know that there was preeminence to the fault, but I think that fault can certainly be a consideration. And the statute provides that fault can be a consideration. It cannot be the only consideration. So for Mr. Erdman...
So does that mean you have to balance the need against the fault?
I think it's a factor that the trial court takes into consideration while balancing need and ability to pay.
The court found that there was no need.
The court found that there was no need, that Ms. Erdman had demonstrated an incredible ability to be able to not only work while she was raising these children, but work outside of the home and carry multiple jobs, and in fact had begun to work for the family business that promised her the career after she was done raising these children. So for Ms. Erdman to present herself as unable to work outside the home just was not factually supported. She had been involved extensively in this, well, for lack of a better term, a pyramid, a multi-level marketing business. She had been involved with the soccer association and held a job with the soccer association.
Yeah, but that paid, what, $3,000? I mean,
it paid more than $3,000. It was part-time, and it paid $6,000. And her multi-level marketing job with Nerium provided an annual income of, at a minimum, $9,200, Ms. Erdman's testimony was that she could have made considerably more. And I believe that the trial court considered that in deciding not to award her alimony. If the trial court had awarded her transitional alimony, it would have essentially taxed Mr. Erdman with Ms. Erdman's bad conduct. She did not need to be rehabilitated, and this was not an appropriate case for alimony in futuro. Ms. Erdman had opportunities for employment readily available then, and she utilized those opportunities. And so while our state doesn't have an alimony that quite fits Ms. Erdman, what she claims her need is, to award her alimony and then tax Mr. Erdman with her bad conduct just doesn't seem to align with the equity of this case. And so our argument is that not only has the trial court made accurate considerations of the facts before her, but one thing I've not mentioned just yet, and I know that I'm just about to run out of time, is that we also believe that the agreed order that the parties entered, which stated that all matters in the case had been resolved on remand and that it was a final order, we believe that that precludes Ms. Erdman now coming to the Court of Appeals and asking for this alimony issue to be revisited when that agreed order comprised the parties' intent and agreement related to what Ms. Erdman then received on remand between the parties' agreement regarding the Pfizer common stock and the Pfizer stock that would be available.
I mean, that agreed order, as you say, involved the stock. It was strictly related to a property division matter, wasn't it?
My client's position is that agreed order considered all of the matters that would potentially be on remand, and that Ms. Erdman received common stock rather than stock options. And that was the consideration for, in turn, resolving all of the matters on remand with that agreed order. She received, I believe, an additional $58,000 rather than what that stock option would have been valued at, which was $5,700.
But that's all that agreement dealt with, was that particular property division issue?
Our argument is that it dealt with all of the issues on remand, and that was a consideration in giving Mrs. Erdman the common stock and the immediate access to that almost $60,000 in addition to the $260,000 that she'd received from the parties' 401k.
All right, thank you, Ms. Russell.
Thank you.
I just want to briefly address the last issue that counsel for the appellant brought up. I think Your Honor was exactly correct in that this agreed order was to resolve the issue of the property division. The statement where it talks about this being a final order was so that it could actually be appealed. I think that Mr. Erdman's argument that Mrs. Erdman would bargain away her right to alimony, which has now been the source of two separate appeals for $5,704 in Pfizer stock, is frankly ludicrous. I would also submit that Ms. Russell did not serve as trial counsel, neither did I, but there was another attorney who was trial counsel who assisted in the remand matters. I put in my responsive or my reply brief that there were extensive communications where Mr. Erdman's counsel was well aware that Mrs. Erdman intended on appealing this issue prior to the entry of this order. It's not in the record, but I did ask the court that I would be happy to submit those emails if that issue is dispositive, if you think that this would be dispositive of this issue. Going back to the award of alimony, I think that Ms. Russell talks multiple times about Mrs. Erdman's career trajectory, and I think that Your Honor was exactly right when you said that that was something that the court precluded the trial court from considering in the determination of alimony, and one of the reasons that this matter was remanded to the trial court in the first place. Again, that's a speculative finding. There was no finding as to how much money Mrs. Erdman would be potentially making in the future. I think that to say that Mrs. Erdman had no need for alimony when she makes $52,000 a year with 6 children, and Mr. Erdman out-earns her about 4 times her income is a pretty unreasonable position to take. Mrs. Russell talked about there not being a good fit for alimony. Well, there's a very good fit for alimony here. It's alimony in futuro in a 17 marriage with 6 children and a stay-at-home mom, and a vast disparity between the parties' incomes, or a transitional award. Either of those I think would be very appropriate under these circumstances, which is exactly what Mrs. Erdman asked the trial court for. Also, going back, the court brought up, did the trial court make findings about Mrs. Erdman not being a credible witness as to her income and expense statement? I think the answer to that is no. I think the adverse credibility determinations were related to this fault issue that the court took great exception to, which I understand, but I don't think it gives the court grounds to punish Mrs. Erdman through denying her.
You think that bled over into?
I think it really did. I mean, there's just really nothing else you could put your hands around that would explain this, because every other factor, Your Honor, weighs in favor of an alimony award. It's just not it's an easy case other than this fault provision. And, you know, the longer we've practiced domestic law, the fault provision becomes very inconsequential generally in an alimony determination, because there's plenty of fault to go around in a 17-year marriage, generally. I would also say that talking about Mrs. Erdman's income and expense statement, counsel brought up that she would look at historic spending. Well, the problem with that we see a lot is it makes expenses duplicative, right? Mr. Erdman puts down the kids' private school costs. Mrs. Erdman also does, because they were both paying that. He puts down the cost of the mortgage. She also puts down the cost of the mortgage. And what that does is the court doesn't have any idea whatsoever of what her need will be when this divorce is over. So what she did was base it on what she felt like she would need when this matter was over, which I think is completely fair. So $1,700 versus $2,500 for housing costs, or $50 for trash that she wasn't actually incurring in her rental property because presumably the landlord was paying it, are all very reasonable differences that should have been considered. And finally, I just wanted to clarify that during the pendency of this matter, Mrs. Russell represented to the court that the children were living primarily with Mr. Erdman. They were not. She was the primary residential parent. They were primarily living with her in a teeny tiny rental house because Mr. Erdman would not vacate the marital home. Does the court have any further questions?
No.
Thank you.
Thank you, Ms. Perkey and Ms. Russell, for your arguments. We'll take this matter under advisement. Call the next case, please.